May it please the Lordship. Lordship, item number 6 for today's list, I may be allowed to call in additional affidavit.
May it please the Lordship. But I beg to mention item number 37, my lord. But here, my lord, an interrogative locative application has been filed for releasing on bail, my lord. So, my lord, matter may be updated, my lord, if your lordship convenience, my lord, after motion, my lord. 37.
May please,
My
Lord.
object.
My lord, I beg to mention item number 13, 1-3, my lord, motion matter. My lord, after filing this matter, my lord, some two documents I have to file. That is, my lord, I have to file additional affidavit. So matter may be adjourned for 2 weeks, my lord.
Item 13.
Yes, my lord.
Oops.
Obliged.
May I please your lordship, I beg to mention item number 33. So this matter
30?
may become of 33 matter. I on behalf of Mr. N. Choikia matter. So this matter may become of next week. He is not feeling well.
Why this has come for orders?
Actually, I am not in this case. So
Just wait. Next.
My please, Lordship. My lord, I have filed a writ petition, Lordship. Petitioner is in custody since three months, Lordship. May I pray for listing the matter on Monday, Lordship?
Give it. Aspect.
Obliged.
My lord, I beg to mention item number 22 and 24. May I pray for upgradation, my lord, after motion matter? There is no bail, my lord.
22 and 24.
22, 24.
Okay.
Obliged.
Miss please, Lordship. Also, I beg to mention item number 35, my lord. Because my lord, in this case, my senior is suffering from, my lord, back pain and vertigo, my lord. So he's unable to present today, my lord. So I'm playing this matter maybe
Okay. 35.
35, ma'am.
Is there something wrong? Why is ECI member here responding here? Election Commission, they have parties here. 35.
35, ma'am.
Is Election Commission is a party here?
Well, there was an issue with regard to the conducting of a panchayat election also. The
By the corporation.
not the corporation, my lord. What had happened was, my lord, the BVCL township, my lord, was brought under the purview of the Namrup Town Committee. That was under challenge before the learned single judge. Now the single judge has observed that the procedure that was carried out was proper. Hence the appeal. Now, following the bringing into the fore of the Namrup Town Committee of the township, my lord, election was conducted. So that is also under challenge. I'm led by Mr. N. Deka, my lord, is indisposed. Or also circulated in the news.
After 2 weeks,
Well,
both sides are represented. They make my call.
May I, Lordship, I beg to mention item number 38, your Lordship, for order. Lordship, kindly begging for the upgrade. Lordship, this is an IA in regards to which petition against extensions of an interim order passed by the Honorable Court.
May please, your Lordship. I have to mention for listing. One I has been filed for correction of the order, my lord.
Give it to the courtmaster.
Item 33.
Notice was issued. I noted it also.
You've not taken steps for responsible for
I will,
More than one and a half.
I will
They have not
inform-
taken steps.
I will inform my and
Okay, for the Land Council with the petitioner and the Bennett submission number and the additional senior government deputy. Is then next. Therefore, adjournment was made on behalf of the land, on behalf of the Land Council for the petitioner. Next, however, the result of the records, it appears from the proceedings of the Lavazima Court dated 25/6/2025, despite opportunities granted, no steps has been taken for issuance of notice on respondent number 4, despite repeated direction. Stop. It is also noted that that despite listing of the matter before the Lavazima Court, on 3 occasions, being 20 January 2025, 3/3/2025, and 25/6/2025, the petitioner has not taken steps. So, next, if these if steps are not taken within 2/8/2025, appropriate orders would be passed on the next date for striking out the name of respondent number 4. Next product. List after 2 weeks.
people.
Daily list item 1 or motion.
My lord, the impugn opinion is at page 48.
Page
48,
23.
48. Yes, 23 one. 6/23.
Land Council for the petitioner. Usual presence to deliver. By filing this petition under Article 226 of the Constitution of India, the opinion dated 6/5/2023 passed in FT case number 3039 of 2011. Page 48. delivered. Issue notice returnable on requi- requisite extra copies be served within 2 working days. Relevant records from the concerned finance tribunal by usual purpose. Therefore, bail will be considered on receipt of records. In the interim, it is provided that if the petitioner has not been taken into custody, but if she's apprehended in the meantime, she will not be deported. She nahi. He will not be deported. Produce a certified copy of the.
Right.
Okay. What are no?
Item 2.
Contested case, my lord, here also, my lord, is declared, my lord, opinion. It was page 79. And sorry, page 79.
Mr. H. Das, run a concept for the petitioner. By filing this the petition under Article 226 of the Constitution of India, the petitioner has challenged the opinion dated 28/2/2025. Page 79. Issue notice returnable in 4 weeks, extra copies be served within 2 working days. Records fall for. The prayer for bail has been opposed by the learned counsel for the standing counsel for the FT matters. The position made in the petition, the court is of the opinion that the petitioner can be granted bail subject to the following condition. On her appearance before the superintendent of police, Gwalpara, Board of Gwalpara, state authorities will obtain necessary information and documentation as required under rules. Failure of the petitioner to release the matter after 4 weeks or on record.
Item 3.
May I please lord? This case, my lord, the contested case, my lord. My lord, order is page number, my lord, 114, my lord. 114, my lord. And it's at 29.
We'll fix we'll issue notice is subject to satisfying us on maintainability.
Pardon, my lord.
You have to address us on maintainability 5 years. Coming after 5 years. What is
5
the-
years delay.
My lord, the petition is, my lord, at the time of my lord, COVID-19, my lord, this order was passed, my lord. Okay, subsequently, after, my lord,
It goes to 1/3/2022.
yes, my lord.
After that. Your first statement in paragraph 45 is incorrect. First line of your explanation in paragraph 45 is incorrect.
Para 45, my lord, petition.
Your opponent, Ms. Verma is more faster than you.
My lord, due to my lord, COVID-19 situation, my lord, this order has been passed, my lord. And my lord, and subsequently, when, my lord,
You have neither seen our smile nor you have seen the smile of your opponent.
Yes.
You have not understood what we are trying to say. first statement in paragraph 45 is incorrect.
Annexure 29 of law. Page 114.
Sorry, my lord, in opinion, my lord, I'm raising my lord, opinion. This one, my lord, is obtained by the learned counsel, my lord. He has not obtained, my lord. Thereafter, my lord, he has collected this
Your
copy.
counsel was better than you,
Yes, my lord, that's why, my lord, and in this regard, my lord.
but your
the-
statement is false.
My
On
lord,
that ground alone, we can dismiss your writ petition. in
my
limine.
lord, the counsel of the petitioner, my lord, has
Look at
collected
page
the.
40, para 45, your statement is false.
Delay, delay.
We are saying politely, we were saying incorrect, but now we'll have to say false.
My lord,
But this is the
the
third time.
counsel did not, my lord, communicate, and that's why, my lord, we could not collect the
Anyways,
copy of order, my lord.
during hearing, lordship on maintainability will also address.
Okay. That leads to dismissal of your writ petition in limine.
The point is fixed.
Sorry, we dismiss your writ petition.
Look, I may be allowed to file additional evidence, my lord, disclosing all the facts, my lord.
For
I may
that,
be
you
allowed
took,
to file, my lord.
3 minutes time. For that statement, you took 3 minutes time. We had to explain it to you for 7 times. Your often Mrs. Ms. Verma had to show you, and then
Madam,
also you
My lord, what happened actually, my lord?
do that, division bench, don't do that, don't do that.
My lord, I may be allowed to file, my lord, additional evidence, my lord, disclosing all the facts, my lord, whatever.
It will not improve
reason
his case, lordship, because the matter, it is all on black and white here, the certified copy obtained and paragraph 45.
My lord,
lordship.
what happened in this case, my lord, the learned counsel has obtained, my
No,
lord.
don't tell us what
Petition-
has happened.
Yes,
That statement of yours at the bar is false.
because.
You know why? Now we will not allow you time. Once you say that, once you blame your lawyer, you are making an incorrect statement at the bar.
That's why, my lord, actually, I am not blaming the lawyer, my lord, and
You
because, my
have
lord,
blamed your lawyer.
due to my
Please
lord-
don't recite.
yes, my lord, due to COVID situation, my lord,
At least,
he could not, my petitioner could
at
not
least-
communicate, my lord.
please try to understand. We listen to each and every word of the
It is-
counsel appearing before us very, very keenly. No word is missed.
It is, my lord, the fact, my lord, that the petitioner could not communicate, my
That
lord.
statement
But-
is false. You are repeating it, we are repeating it for the 5th time, that your statement at the bar is a false statement. Let me read paragraph 45. In 45, you say, the petitioner begs to state that there is delay in filing of the writ petition initially due to the situation of COVID-19. And moreover, it takes some time to obtain the certified copies of document from the learned tribunal below. This order was obtained in 2020. And then you say, and to obtain other documents and arrange fees for advocate. Moreover, he could not communicate with his engaged advocate to get instructions for filing the instant writ petition.
There are some other.
No, false statement at the bar will not encourage. You're dismissing it.
My lord,
sorry.
there are some
Yeah.
other causes, my lord. I may be allowed to, my lord, file additional.
You
evidence,
have
my lord,
better
disclosing.
options now. This
Well,
is something when
this
a
is-
false statement
my
is made
lord,
at the
my-
bar.
At that moment, my lord, there is, my lord, due to COVID-19 situation, my lord, there are
We
so many
have read your
cases, my lord.
statement. If you can't read your own statement, we have read it for you.
Then everything, my lord, I have to obtain, my lord, this document.
No, false statement we will not encourage.
This is not, my lord, fault, my lord, this
We
is as
were-
per, my lord.
We were smiling all throughout, giving you an opportunity. But then you made an explanation. And this explanation is false. We will not encourage that false statement. It,
My lord, I may be allowed, my lord, otherwise, my lord,
no. You should have said that first. And you should not have insisted on a false statement, despite telling us, this is the 8th time I am telling you that you have made a false statement. We will not encourage that. And you are showing no remorse. Rather, we could have proceeded against you in contempt. No, this false
I'm
statement
sorry,
will not be
ma'am.
encouraged. No,
I'm
Mr.
sorry, ma'am.
Heard Mr. S. Ahmed, then counsel for the petitioner. Also heard all the respondents are there. Next. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 12/6/2020, passed by the learned member from a Foreigners Tribunal 9, Borpeta, in page 114. By which the petitioner was declared to be a foreigner of post 25 to 1971 stream. As there is inordinate delay in approaching this court to assail the impugned opinion, we had requested the learned counsel for the petitioner to address us on the issue of delay and latches. While addressing us on the said issue of delay and latches, the learned counsel for the petitioner has made a false statement at the bar that due to COVID-19 situation, that after COVID, the initial delay was due to COVID-19 situation, and thereafter the petitioner could not. The petitioner took some time to correct the documents. Thereafter, he has changed his version to say that the petitioner had lost communication with his learned counsel, for which the copies could not be corrected. He also submits that the certificate copies were not collected by the petitioner, but by his learned counsel. Full stop. On the contrary, statement made in paragraph 45 of the writ petition, which is sworn and verified to be true to the knowledge of the petitioner, is to the following effect. Page 40, paragraph 45 at page 24. From the statement to the contrary appearing in paragraph 45 of the writ petition, the statement made by the learned counsel to the petitioner at the bar is false. And despite repeatedly informing the learned counsel that he was making a false statement, he insisted on the said statement. Next paragraph, therefore, as the delay in latches occurring on part of the petitioner to present this writ petition, to assail the impugned opinion dated 12/6/2020, the writ petition deserves to be dismissed, which we accordingly do. Full stop. The court is inclined to record that as an incorrect statement made at the bar affects the administration of justice. Yet the court has refrained itself from issuing process against the learned counsel for the petitioner for committing contempt of court. Next paragraph. Recently, in view of the inconsistent statement made at the bar, which is contrary to what has been stated in paragraph 45 of the writ petition. The delay and latches, having not been properly explained, or the declaration can dismissed in the meaning without issuance of notice on the respondent.
Obliging.
Item 4 or motion.
May it please the Lordship, this is contested matter and opinion dated is 18 to 2020, Lordship, page 33. Page 33, Lordship. Lordship, yes. I have explained in para number 30, Lordship. Due to financial constraint, Lordship, I am not able to approach before this court within a time, Lordship. Para 30, page 26, Lordship. Lordship, we are providing pro bono and before filing this writ petition, they recently approached us, Lordship. We are providing pro bono, Lordship, so before filing this.
You see, we'll tell you why we are questioning you on this. Your writ petition starts with with a statement that you have land,
Yes,
correct?
yes.
Once you say that you have landed properties, which was there with your grandfather inherited by you, then the statement that you are poor is inconsistent. You have to say something more. You are a young lawyer, we don't want to dismiss it. To improve your, to file an affidavit. Such as a representative of the pair made by mistake hasn't done today, this storm.
Lordship, yes, Lordship.
When?
Within a week.
Is a calendar, tell us the date when we'll fix it.
Lordship, 11.
Item 5,
Same thing here also 2020,
Yes, Lord.
same order. Which is not satisfactory.
Obliged, sir.
Yes, Mr. Barat.
Petition and against order at 12/6/2020, my lord. Some delay was
Page,
is made, my lord, but I stating my para, my lord, your lordship go to para 24, my lord.
no, opinion is
Page
at which page, Mr. Barat?
My lord,
Opinion is at which page?
opinion page, my lord, next are 15, page 70.
2020.
My lord, 2020, my lord.
This is a year-
12/6,
the day of
2020. My lord,
This is a day of 2020.
2020.
All cases of 2020, yes.
My lord,
What is your explanation?
actually, my lord, I am going to in verification report. Nothing has been
No, don't say about that. First
My
is
lord.
the explanation of delay.
delay, my lord. Your lordship go through it, my lord. Para 24, page 15, my lord. Sorry, sir. Para 24, my lord. 24, page 15, my lord. That the petitioner is a rustic person and studied up to class 4 standard, having no basic knowledge, and consequence that she can approach her higher judicial forum in time of for scrutiny of the opinion dated so and so passed by the so and so below executive. Moreover, her husband is a handicapped person having 45 disability who cannot move here and there properly. The authority concerned have issued him the ID card in this regard. However, a co-villager has recently informed her that she can approach the High Court after getting information. Your humble petitioner collected the papers of the tribunal as well as from her engaged counsel and handed over so and so. Your lordship go annexer 16, my lord. So annexer 17, annexer 16, page 77, my lord. The locomotor disability her husband, my lord, 45%. And if I going to meaning of the locomotor disability of the persons with disability, my lord, Protection Right Act 1995, means disability of the bones, joint, or muscles leading to substantial restriction of movement of limbs or any from the cerebral palsy, my lord. So, my lord, this last
Ms. Verma? Because of the disability.
This was issued only in 22, Lordship, after the order was passed. Order was passed in
Yes,
20.
we issue a notice on maintainability also.
No, my lord, page 70, actually, this is the new I-card and original I-card, page 78.
78.
78 page, my lord.
Okay, we are issuing a
The
notice.
2009, my lord, this disability I-card is there, my lord, 2009. Page 78, my lord. And now they digitally given, my lord, this is, my lord, page 60. Both are, I'm going to annex, my lord, actually. No. Absolutely.
Item 7.
These losses. This is my contested case, my lord. There's a case, my lord. Yes, 80, my lord, 80.
Big time.
Let's be verbatim. Obviously.
Item 8,
Maybe lot. Maybe more test 33 my lord.
20, yeah.
33 my lord. Don't know that.
83,
Yes, my lord.
625.
No go. No go. No go. No go.
Hello.
item 9 for motion.
Like, this is a contested case. Opinion is in the page number 28, your lordship. Page number 28 is in the opinion. Yeah. The opinion dated is lordship, 25/2/2020. 2020 lord.
Your explanation for the delay?
Lordship, in the petition was mentioned in the page number 13, paragraph 27, your lordship.
Page 13.
Page 13, paragraph 27. Also, like, unable to gather.
But this is too vague. for
Lordship, the same,
acceptance.
in the paragraph 13 of page number 8, I was not provided with the certified copies of the annexures there for the long time, your lordship. The orally, tribunal has said orally that while the issue will notice, they will provide the exhibit documents. Hence, I was not provided with the necessary documents, your lordship.
Lordship, may kindly come to Annexure 2, Lordship. The first page, Lordship, it's a IMDT reference of 1998. Notices went out. The last 5 lines, Lordship, however, though necessary proceeding against opposite party was initiated, it dragged on with effect from 1999 till filing of the case by an order passed on 7/1/2004 on the specific ground that the police could not trace out the opposite party in the said case, Lordship. So all through the proceeding has been evading accepting the notice also, Lordship. The next page is more clear, Lordship, on that. Notice was finally issued on 26/12/2018, Lordship.
You see, with the nature of documents you have annexed, very hard to believe that you are having less resources to less models. Come to page 29. Document at serial number 12 will not be available.
Lordship, I was not provided with the.
We understand, but it's very difficult. You're a young lawyer, we don't want to disappoint you, we have done it. But this is something it's not acceptable. Your statement doesn't inspire confidence. You say that copy was not provided to you. But with my limited experience, no court has ever taken the trouble of providing at least me copy during my limited experience I have. You never invited me and gave me a copy. I had to apply for it, get it. So that statement doesn't inspire confidence, but we are a young lawyer, we don't want to disappoint you. As a representative, we have made my possible. This can be adjourned today, based on 7/8/20. Just adjourning it.
See, Father.
Okay. What says it?
Right.
Item 10.
May please Lordship. The petitioner's brother were declared foreigner by the tribunal and presently matter are pending before this honorable court. In those matter, Lordship, notice was issued and LCR called for Lordship. May this matter tag along with the other matter, Lordship?
Lordship, it's a ex parte order of 2021, Lordship. Yes, sir.
From
it
review
was
also, there's a
dismissed
delay.
24.
Lordship, other matter are pending. Other matters are pending, Lordship.
Which other matter?
Petitioner's brother were declared foreigner, Lordship, and on 30/7/2025, notice was issued, Lordship, and LCR called for. And fixed on, Lordship, 1/9/2025.
You have the last order we passed for your brother.
Lordship, I don't have the order.
Okay, what?
In WPC 4232.
42 of 25.
2025. Yes, Lordship.
You have passed an order, which date?
30/7/2025. Lordship. Yes, Lordship. 2505, 2025. 2505, 2025. B does. B. A B. Okay.
So my page 29
Yes.
doesn't have the
134, Lordship, object 2022.
one,
134.
where do you have that number?
Page number 8, Lordship, paragraph 7.
Even on page 32, Lordship will find the case number, Lordship, last page of the petition. Last, as a result, the petition number is going to, it's one.
This is petition number,
Yes,
not the case number. Okay. Petition. Okay. Okay, there.
2024, part A. Petition number 134 of 2022. Petition number 134 of 2022, dated 25 to 2020. So, part nine,
Lordship, since it's a ex parte order, issue of maintainability should be kept open, Lordship. Because they never filed
Review
anything,
also.
Lordship.
Reviews
Delay.
there we have an
They
explanation,
have, but that is in 24, Lordship.
but once the review is entertained, we can't have that issue
that-
taken up again.
Most of nice.
That is okay. All right, right. That's not reported. So, what is
Where is she? Logic and practice.
Dibrugarh Lordship. What's the base?
Item 11.
My pleasure, Lordship. In opinion, page 51, my lord, 15/10/2022, it is announcement, my lord, expert your friend, because after filing written statement,
Page number?
page 51, my lord. After filing written statement, my lord, appending there to certain vital documents, thereafter remain absent, my lord. And then on 15/10/2022, Learned Tribunal rendered its opinion saying that the document which were or statement made in the written statement does not stand as the petitioner failed to adduce evidence. But along with the my lord, written statement, it is page 51. Along with the written statement, it is submitted, my lord, opinion of the Learned Tribunal, one proceeding was initiated against the father of the petitioner, my lord. Learned Tribunal on 6/10/2016, my lord, after my lord examining the all my lord oral testimony documents exhibited and produced by the father of the petitioner, hold that the father of the petitioner is not a doubtful citizen. Page 62, my lord. No, page 62. We want to report or local verification officer. There's after my lord filing written statement, my lord remain absent.
Where is
remain
your written
absent.
statement? Which page?
Why
the
do-
Statement?
Why he remain absent, my lord?
No, where is your written
Why
statement?
not? That I have stated, my lord, I also
Where
included
is
my
your written statement?
page 19, my para 19, page 20.
No, where is your written statement?
Written statement, my lord, you also find page 34. Page 34, my lord. In the written statement as well, in para 10 of my written statement, I have clearly stated regarding the opinion rendered by the tribunal about my father and I. And so for the and I wish to enclose my lord order passed by the Learned Tribunal since the day of filing written statement. And when I remember why I was remained absent, that I have my lord stated in para 19, page 20 of my petition now. I have also annexed, my lord, orders by the learned tribunal with effect from 10/1/2022, page 43 onward. You know, I explained in para 19, my lord. Para 19, page 20, my lord, because what happened, my lord? I filed a written statement on 4/12/2021. The case was next fixed on 10/1/2022. That I also include, my lord, page 43 also passed by the order, learned tribunal, orders passed by the learned tribunal. Page 43 onwards. 10/1/2023, State Council filed an application saying that he is suffering from COVID-19, so he hospitalized in name care hospital. Accordingly, the matter was adjourned till 19/2/2022. On 19/2/2022, what happened, my lord? I met with my engaged counsel, my lord.
We are issuing notice that
The father of the petitioner, he is a declared, first of all, the father of the petitioner is concerned, he is only declared Indian citizen, my lord.
the printed will not be deported.
Protecting, my lord, because so far as my lord, yes, what the law requires,
From 2022 onwards, he did not take any step to even
And the-
find out what has happened to the case.
No, my lord,
He did not inform me, he started not communicating.
honestly submitting before this honorable court. Now, my lord, he is apprehending, my lord, because of the present situation, my lord.
He will not be deported if acting. Let the records come.
If possible, also. Because I have, so far as the vital document that I have improved. My lord, learned tribunal, my
Mr.
lord,
Ahmed, Mr. Ahmed, every time we say here, while hearing petitions like this, we always normally ask the learned counsel for the petitioner to give an undertaking that if the clients do not contact you, you will keep on informing them. I have not seen any lawyer who's undertaking that, yes, okay, I'll do it. Even if my client doesn't come, for years together, I'll keep him informing every time about what is the status of the case. I'm yet to find a lawyer
my
with
lord.
that amount of zeal and enthusiasm.
No.
You have not stated, the petitioner has not stated about his conduct. How many times he has gone and visited his lawyer?
My lord, on 19, on my, I'm stated, my lord, on 19/2/2000, date was after 10/1/2022, date was fixed on 19/2/2022. On that day, I met the English council. The rest, my lord, he took fee and took signature in a white paper. Then told me to go. I left. Next date fixed on 29/4/2022. Same thing happened. Next date fixed on 35/2020. Yes, on 35/2022, I informed my English council at least make an application saying that, my lord, I'm going to my Arunachal Pradesh because of some official work of my father, as he was the employee of Arunachal Pradesh. Then case was fixed on 7/7/2022. On 7/2022, I appeared before tribunal. I appeared. On that day, my lord, London English Council filed an application saying that he needs some time to amend the written statement, my lord. That I have enclosed, my lord. Petition I have enclosed. Order passed by London Tribunal, I have enclosed, my lord. Paragraph 43 onwards, my lord. Then London Tribunal dismissed the said petition and close the evidence on fixed on next date fixed on 15/10/2022, my lord. In accordance 15/10/2000 is opinion, my lord.
I, we sentence you to bail at this stage. Bail will be considered on receipt of records.
Yes, sir.
But Mr. FKR Ahmed, the counsel for the petitioner and filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed 51.
15/10/2022, my lord.
Issue notice returnable in 4 weeks. Requisite extra copies be furnished to the counsel for the respondents within 2 working days, with the relevant records be called for from the concerned tribunal. The prayer for bail shall be considered on receipt of the patent record. However, in the meantime, if the petitioner, namely Afzal Hussain, is apprehended, he shall not be deported out of the country without orders of this court. Petitioner shall produce a certified copy of this order before the
On SP Sunitpur.
SP Sunitpur. List on
Lordship, may I submit lordship? LCR of the father also may be called for that. His WS would also have to be examined whether he has stated he is a son or not. Lordship. Otherwise.
I have enclosed by my lord, their birth certificate issued by the state of Arunachal Pradesh.
LCR of father, because he has been declared Indian.
Birth certificate page 69, my lord. My birth certificate.
LCR to the call for police.
That's a page 62, Lordship.
Along with records, page, what was the
The
page?
same tribunal, same member, Lordship.
Page 62.
Along with the records of
Lordship, case number 293/16. Yes, Lordship.
on receipt of DCR.
Item 12.
Absolutely. 21 or
Lordship, this is second time the petitioner is before your lordship, lordship. But before opinion, lordship, there is a background I'd like to highlight. Lordship, initially after receipt of notice, opinion lordship is
215.
215 lordship, it's that. Yeah. Lordship,
Ladies and
no lordship. That has not been.
How have you explained the delay for 2 years in approaching the and challenging the order. This page 215 is of 17/5/23. In your petition, how you have explained the delay? Because if you have given any explanation, we have missed it.
I have to file an addition of it.
Because we have to excuse you for these 2 years.
That's why I file an addition letter. Your statement on delay is not there.
Not that this way we missed it out. You fixed it on 11th? 11th, by 11th, you will be able to file it?
By 11. That's right.
Both sides are represented on the made by Mr. Yu Datta and this on 7/8/25.
Obliged.
Item 14.
Yes, Lord.
Yes,
My lord,
page number
page 68 is the open.
58,
68.
68.
You are Mr. Islam,
M. Ali.
M. Ali.
No.
But Mr. M. Ali, and counsel for the petitioner, also had. By filing this petition under Article 226 of the Constitution of India, the petitioner has challenged page 68. Issue notice returnable in 4 weeks. Requisite extra copies be served on the learned counsel for the respondent to get paid within 2 working days. Let the relevant record call for from the concerned tribunal. The prayer for bail has been opposed by the learned counsel for standing counsel for FT matters. However, in view of the projection made in the writ petition, this court is inclined to grant bail to the petitioner, namely Hasina Khatun alias Hasna Khatun, on the following terms and conditions. On her appearance before the
ST border Gwalpara.
Board of Gwalpara, on the failure of the petitioner to appear, please the matter after 4 weeks or on receipt of the records from the family.
Obliged.
Item 15.
Please, Lordship. My lord, page 80 is the improved final opinion. Page 80, Lordship. If I am on board,
Now it have to be considered on receipt of records.
but only 20 days delay.
It's okay.
Then 1 year for filing the petition, but you can consider that. I'm on board, Lordship.
But when you
Not it means.
when you can vote timely, we don't ask any questions. Can't help it. We consider on receipt of records.
Otherwise, clear linkage is there.
Heard Mr. M.I. Hussain for the petitioner. Also heard. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has challenged page 80, the opinion. Issue notice returnable on 3rd of September. Requisite extra copies of the petition be furnished to the learned counsel for the respondents within 2 working days. Let the relevant records be called for. The prayer for bail shall be considered from the next returnable date. In the meanwhile, if the petitioner is apprehended, she will have to report it without further order. Petitioner shall produce a certified copy of the order before the
SPB Dorong.
list. In September.
Keep developed.
Do you have the date of marriage? No.
Yes, the date of marriage is not clear, Lakshmi. But that statement is there that I was married, Lordship.
You just tell us the year of marriage, if you are aware. Date of marriage, are you aware? No.
No,
Uh, when is the last shifting done? In your case? Shifting was done when?
yes, this was shifting was done on several occasions in nearby village, Lordship. And sometime due to the delimitation of the area, Lordship, the village name appeared differently, Lordship. That is there.
And is, come to page 45. Come to page 45. This is a Lat Gura of Borai Para, Barai, correct?
Lordship.
Now come to page 3. It's a different spelling. Is the same village or different village?
Lordship, sometime it is written in Barai Para, sometime it is in Barhai Para.
Oh,
Barhai Para. It's the same village, Lordship.
alias for village also.
Barai Para, Barhai Para.
No, it's okay. It struck us because the name is different, so therefore why there could be a difference?
Yes, how much pronunciation of that?
Then come to page 46. Assamese it is Baroi.
Baroi. Baroi Para, Borhai Para, Borai Para, these are the.
So and so, alias, so and so, alias, so and so. So whatever will be prepared on the next date. You must also understand that we value your words. You read it carefully.
Item 16.
May I please, your lordships? Lord, the impugned opinion dated 27/3/2024 is under challenge, my lord. And it is my lord, it is a contested
At
case.
which page?
My lord, may we please to find at page 117, my lord.
Page 17.
Yes, my lord, altogether, my lord, 17 numbers of exhibits were relied on. And the learned, my lord, foreigners tribunal, my lord, the,
But you'll have to wait for some time for bail.
my lord,
You'll have to wait for some time for bail.
I am, my lord, we have tried our best to approach immediately before my lord. My lord, what has happened? Some documents, my lord, we could not get
No,
access.
it's okay,
My-
but we are going by a thumb rule.
My lord, my lord,
Once you come on time, you don't ask any questions.
my lord. And my lord, there is a little delay, my lord.
We had a bad experience in our lives.
My lord,
1% I did not get and I did not get secure first division.
my lord.
Very bad experience, only 1%.
Sometime happens. my lord.
Sometime it happens.
By preferring this writ petition under Article 226, the Constitution of India, the petitioner has assailed the opinion, page 117. Issue notice returnable by 39, requisite extra copies of the writ petition be furnished to the council for the respondents within 2 working days. That the relevant records be called for from the concerned foreigners tribunal.
Moreover,
For bail, be considered on the next returnable date. In the meanwhile, if the petitioner is apprehended, he
my lord,
he
my lord, if
he
that-
will not be he will not be deported without further orders of this court. Certified copy of the order of the court be presented before the
SP Morigaon.
SP Morigaon.
My lord.
List on page.
SP Morigaon border, my lord. My lord. Morigaon. Now, from the explanation.
Item 17.
Obliged, highly obliged. So, my lord, my respected senior friend corrected me with SP border Morigaon. I have very limited experience, so there are some mistakes on my part. My lord. My lord. My lord. Yes, yes. My lord. Sometimes, my lord, they don't accept the order also, my lord, if there is a mistake. My lord, that's the problem. Obliged, highly obliged. My lord. My lord. My lord. Obliged, highly obliged. That's, Lordship, page 46 is the opinion. 46. 46. My lord.
Heard Mr. M. Ali,
Lord.
learned counsel for the petitioner. Also heard that filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the impugned opinion, page 46. Issue notice returnable in 4 weeks. Requisite extra copies of the writ petition be supplied to the federal council for the respondents during within 2 working days. Let the relevant records be called for. The general counsel for the respondents have opposed the prayer for bail. However, in view of the statements made in the writ petition, we are inclined to grant bail. The petitioner, namely Saifun Nessa alias Saifan, on the following terms and conditions. On her appearance before the
SP border Borpeta.
failure of the petitioner to appear with list the matter after 4 weeks or on receipt of the ECR.
Obliged, my lord, highly.
18.
Please, your, may I please your lordship.
It is a lordship, the Connecticut
May I
Council.
please your lordship.
Please, my lord. The Connecticut Council is on PC lordship.
May I please your lordship. It is a list. Lordship, only one typing mistake is there in the order dated would be 23/5/16. It would be 23/5/16. It was written only 16/5/2016.
Which page?
Kindly,
Which page?
Lordship, page number 26.
26.
Yes, lordship. The prayer.
annexure 14, page 56, para 17. Allow us to correct, lordship. It very apologize myself. My brother colleagues are make a mistake. Court also not been looked into.
In the prayer, that is a mistake.
14.
In the prayer, there is a mistake.
Yes, lordship, page number 26. 26, lordship.
Okay. Okay. we'll
It
allow
ought to
you
be
to
lordship.
correct it. Yes. Yes, please tell us. Please
This
address
matter, already matter goes to Supreme Court, return back. Then in so moto, Supreme Court pass an order because of more than 2 years suffering in detention camp. In so moto, allow us the petitioner on bail and
Where is the impugn order? Which page is the impugn order? Which page is the impugn order?
Section 14, lordship.
Eh?
Section 40, 56, lordship. 56, lord.
56.
Yes, lord.
only because of proper steps and the link deed has not been given by earlier advocate.
You address us on the issue of maintainability. You are challenging it after 2016, after 9 years. Address us on maintainability.
Because it is not red judicata. It is not red judicata. Because new fact, my lord, it is a new fact. Recently, Supreme Court passed the judgment. It is a totally new fact. It is not attracted red judicata.
What is the new facts? What is the new facts?
New fact number one, the link deed had not been given earlier. Now on a family tree has been given. Family tree has been given. Kindly see the family tree. Lordship, kindly see the first family tree. Enter family tree has been given, supported with the link deed. Link deed has not been given earlier.
Okay, that is the only ground? Is that the only ground? Is that the only ground?
This is a totally new fact. Ground because he was the son of the person who and then the forefather, and originally Jamabandi copy is in 1940 and 1941. Jamabandi copy was in the year of 1940. Still the petitioner living on the same plot of land that was not brought before the court earlier. And on the defect of an advocate, client cannot be suffered. I have citation all judgment before Lordship.
Where is the list of judgments? Where is the list of judgments? Where is your list of judgments?
I have given the judgment. My very humbly say, if you allow, we are submitting all the judgment before you. My brother colleagues are sitting in the courtroom. If you allow, we will submit all the copy before you. My brother colleague will submit all copy.
Kindly come to page 60, Lordship.
The paragraph numbers. Give the paragraph numbers. You don't want to spend a time.
Apart on that, Supreme Court is so motto Supreme Court because of suffering 2 years, he is on the bail and giving regular present before the police station.
Yes, Ms. Verma.
Page 60. Page 60, Lordship. We already approached this court and it was dismissed, Lordship. By reasoned order. Same reference, Lordship.
A bona fide citizen cannot be thrown away. All the document has been there. He is a citizen of India. Supreme Court recent judgment and constitutional bench have laid down the law. It is a valid law.
Even Supreme Court has dismissed it.
On delay,
Even Supreme Court has dismissed it.
on delay, Lordship.
Dismissed, Lordship, but a second petition would lie, Lordship. I think we should have filed a review, Lordship.
Lordship, kindly look into the family tree. Lordship, kindly see the NRC document. Lordship, kindly see the NRC document, which was not earlier given. NRC document, page 77, NRC document, page.
Okay, we have seen that. We think the second petition would not be maintainable.
Yes, Lordship.
Kindly see the NRC document, page 75, 77.
We have seen that. We have seen those documents. We are not convinced that a second petition would be maintainable.
Earlier, NRC document was not given. all
Okay. Heard.
Lordship can, if Lordship doubt, Lordship can remand back the matter to take all the evidence.
No, second writ petition would not be maintainable. We are dismissing it. Heard. Mr.
Lordship
Dean,
can remand back the matter to take all the evidence.
who has appeared through video
That
conferencing.
judgment I have set aside. Lordship kindly
Okay.
serve another several case also.
Also heard. DSGI, the response there. By filing this writ petition under Article 226 of the Constitution of India, the petitioners assailed an opinion dated 23/5/2016, asked by the learned member, page 57, by Swenson Jones, thereby declaring him to be a foreigner post 25/3/1971 stream. From the materials available on record, it appears that the petitioner, namely Mohammed Moinul Haq, had challenged the same opinion by filing WPC 5122 of 2016. And the said writ petition were dismissed by order dated 7/3/2018. It is noticed that the said order dated 7/3/2018 passed by the division bench of this court in WPC 5122 of 2016 was assailed before the Supreme Court of India by filing a special leave petition within bracket civil, whose diary number 12074/2024, page 65. Along with separate applications for condonation of delay, comma, make it semicolon, exemption from filing certified copy, semicolon, exemption from filing OT, Madam, please. No, you. What is the short form of OT in Supreme Court? IA for exemption from filing OT. OT means what? Sure, page 65. Sure, page 65.
Yeah.
Original something.
In the middle, exemption from filing OT.
Even I don't know.
Okay, it's just OT, write it OT. It's okay, thank you.
I can find out.
No, it's okay, not required. OT to our mind goes operation theater.
Yes, that's it, yes. It's exemption from filing. Original translation, I don't know.
No, we don't know since It's okay, it's okay, it's okay. Means, I have asked you because of the reason that I normally in my orders, I try to avoid shortcuts.
Yes,
what
it's
they call,
difficult for people to understand, particularly if you're not used to that.
terminology.
Terminology,
So
yes.
abbreviations I normally omit, but
And unfortunately, Lordship, I was not an advocate in record in Supreme Court. So I am also not aware of all these
okay, terminology.
shortcomings.
Okay, okay.
Lordship, may I, my lord. In the context of Supreme Court of India, the exemption from filing OT means an exemption from filing the official translation of documents.
Officially translated,
Translation of document.
putting within bracket official translated document bracket two, and semicolon, and continuation of delay in refiling public curing the defects. Full stop. The Supreme Court of India by order dated 3/5/2024 found the delay of 2109 days in filing and 10 days delay in refiling of the SLP not sufficient, and consequently the special leave petition was dismissed on the ground of delay. Next part, the learned counsel for the petition has submitted that on new grounds, the present writ petition has been filed. Which are number one, which are firstly that the family tree has been now annexed to the writ petition. And secondly, land documents have been now produced. Next one. The the learned counsel for the petitioner has submitted that some delay occurred as the petitioner was apprehended and was taken into a detention camp for more than 2 years. And it is further submitted that the earlier counsel did not guide the petitioner to produce the link documents or the land documents, and therefore it was on wrong guidance that the earlier that we defended the proceedings before the tribunal. It was carried up to this court by filing a writ petition and then up to the Supreme Court of India. Next slide. The learned standing counsel for the FT matters has opposed the maintainability of the writ petition on the ground that the second writ petition would be barred by the principles of res judicata, next part, we considered the materials available on the part as well as the submissions made at the bar. We also considered. We take a short break and come back. You have this judgment. What is that? In the paragraph. You've given the paragraphs.
No,
Give us the
Lordship,
paragraphs.
some time to. And some time to write the paragraph.
No, no time, we are dictating the order. If you miss it, you miss it. We'll take a short break and come back.
Lordship, Lordship.
We'll take- As well as also cited by by the land council for the petitioner. Next matter. On a. This is on a perusal of the materials available on record. It is noticed that there is another proceeding against the petitioner, namely Mohammed Moinul Haq, being case 67, being case number so and so, police reference number case so and so, which was before the learned member, Foreigners Tribunal, Second Morigao. On a perusal of the order dated 13/10/2022, which is annexed to this writ petition, as Annexure 17, it is observed that the petitioner had filed petition number 155 dated 13/10/2022 before the said learned tribunal, stating therein that another case, being case number FT 107 of 2012, was pending before this court in connection with WPC 5122 of 2016. The said learned tribunal, on a perusal of the order dated 7/9/2016, passed by this court in WPC 5122 of 2016, made an inquiry from the website of this court and found that WPC 5122 of 2016 was disposed of by this court by order dated 7/3/2018. Accordingly, the said learned tribunal formed an opinion that on the dismissal of the writ petition, the opinion dated 23/5/2016, passed by the same learned tribunal in FT within bracket C, bracket close case number 107 of 2012, was upheld. Full stop. Accordingly, in connection with petition number 155 dated 13/10/2022, the learned tribunal had held that apparently a false statement was made by the petitioner before the said learned tribunal. So accordingly, on the petitioner being declared a foreigner, or already declared a foreigner in connection with FT within bracket C 107 of 2012, the proceedings of FT 2091 of 2012 was held to be part by judicata and not proceeded. Next one. The cases this bunch is cited by the learned counsel for the petitioner are not found to be authorities on the point that after dismissal of a writ petition, on new grounds, a second writ petition could be filed to assail the opinion dated 23/5/2016. Accordingly, the court is concerned to hold that, court is inclined to hold that as this court by order dated 7/3/2018, passed in WPC 5122 of 2016, has already dismissed the challenge made to the opinion dated 23/5/2016, passed in case number FT within bracket C 107 of 2012, passed by the learned member from a foreigners tribunal second Burigo. Even on new grounds, a fresh writ petition would not be maintainable, as the same is hit by the principles of judicata. Moreover, on the said ground, the learned member from a foreigners tribunal second Morigao, by an order dated 13/10/2022, has already stated the proceedings of case number FT 2091 of 2012 on the ground of res judicata. This is yet another reason for not entertaining a second challenge to the same opinion under Article 226 of the Constitution of India. Next, resultantly, this writ petition is without any merit and the same is dismissed without issuance of notice on the respondent.
Right.
Item 19. Item 19.
Just a moment. Moreover, when SLP is against the order of this court has also been dismissed by order dated page 8.
Yeah, Lordship, imping opinion, page 82 Lordship. 82 Lordship. Dated Lordship 28/8/2023 Lordship.
heard Mr. R.C. Das. Heard counsel for the petitioner. Also heard. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion issue notice returnable on 3/9. Requisite extra copy please of the respondents within 2 working days. Let the relevant records be called for from the concerned foreign tribunal by usual process as well as by email. Therefore, we can be considered to be so. However, it is provided that in case the petition is apprehended, he will not be deported without further order to.
To the page number 79, here the another notice was issued by the Honors Tribunal 2 lordship. So this page number 79 lordship. So I have given the order dated 4/4/2025 lordship. So is the type to be lordship. The notice is the second notice lordship. That notice not maintainable. So after the declared the opening law.
This is another proceeding.
Yeah, another proceeding lordship. I don't know. Lord. So we have not. Is the one. I have not.
You have one more question. Reference to petition.
The learned counsel for the petitioner. Yes, Ms. Verma, what do you say about this? The page 79, another proceeding against the same person.
Yes, Lordship, but this may be stated in this, this comes with logical end, Lordship. This is already, the imputed opinion is here now whether this person and the declared foreigner here in this petition are one and the same person. That is the only crux, Lordship. I was just trying to see the notice, Lordship, at page 79.
No, what we can do is, as Mr. Das has pointed out
Yes, Lordship.
about this page 79, can we do that, we permit the, keeping this issue open, we ask the petitioner to file his
Yes,
this
Lordship.
opinion, and therefore if the tribunal finds it is the same person, res judicata will apply.
Yes, Lordship. That is it. That is the way. it goes,
Instead of keeping
Lordship,
it pending here.
Earlier, okay, okay.
Hmm?
82. Now, Lordship, the only crux is 23 Lord. Lordship, since he has accepted the notice, he has appeared. This
That's right.
proceeding has started. This cannot stop now. It has to come to its logical conclusion.
That's right. Logical conclusion, if the res judicata applies,
Yes.
he doesn't have to suffer a second proceeding, but he will inform the tribunal with all the record that he is the same
Yes,
person.
Lordship.
Because what has happened, we have noticed, my esteemed brother has taken note of the fact that in the impugned opinion, please see that. That is at page,
82 Lordship.
no, the original one,
Original is 96.
96. We come to that, page 96. Here the address is given as present address. That means
Yes.
perhaps he would be on temporary staying at this place. So we don't know about the address.
No,
So-
actually, this does not say which tribunal. It's Nagaon only, Lordship, and this is
No,
also
no.
Nagaon, 9th
No, no.
Nagaon.
Page 96, you see the present address is village Magurmari.
Lordship.
And in the
Thank you.
notice which now Mr. Das is showing, which is at page
79.
79, you see the address is different. So therefore, instead of keeping it pending here, we desire that this petitioner will go there and show all these documents, and the tribunal will consider and close it.
But He's not, fair to position it, because you are fair after. He has no prayer for this petition, your lordship.
It is.
No,
There's a prayer, not very happily worded, but it's there.
Because this one will be decided by lordship here. The second one, he has to.
That's why we are
yes,
saying it here, instead of
that's it,
keeping it
lordship.
here.
But this,
Tribunal counsel for the petitioner has drawn our attention to annexure 10 of the repetition, stating that a second proceeding is now pending before the Awareness Tribunal number 2, Nagaon. Petitioner will be at liberty to bring to the notice of the said tribunal the pendency of this proceedings
lordship, the
as well as the earlier opinion.
opinions, yes.
As well as the earlier opinion, the tribunal will pass necessary orders on such. Prayer.
Lordship,
After
this
examining whether the petitioner is the same
one and the same
proceeding
person.
in both the proceeding.
Lordship will clarify that, the writ petition filed here, it should not be a bar not to proceed with this one. What happens is, when this order goes, they think that until and unless this is not disposed of, they will not proceed with that.
The pendency of the
Writ petition should not be a
petitioner will
bar.
not be a bar.
Yes, Lordship.
Proceed with the for the Awareness Tribunal number 2 to proceed with the
Notice dated.
notice
At
with the
second,
notice
FT second Nagaon, Lordship. FT second Nagaon. I don't have the case number here. It is FT 3511.
In order dated 4/4/2025, Lordship. Case number, application number 3596 oblique 2011.
3596 with application number 3596 of 2011.
11. And tribunal order dated 4/4/2025, the issue notice, Lordship, second time. So I have applied
4/4/2025, you were required to appear. It is not a notice date.
He's already appeared, Lordship. The order sheet appeared, Lordship. This is the order sheet. It says notice duly served and petitioner has appeared, Lordship, and next date also filed. Yes, and Lordship, this is of 2011, and before this court is the proceeding is of 2018.
18.
Yes,
If it is the same.
yeah, if one and the same person,
Tribunal will take a call.
call on it,
See?
yes.
Not to proceed.
Yes.
It not be that.
Here and I'm very much shocked, Lordship. So yes, proceeding also and Okalatama, Lordship.
It's already appeared, filed
Appeared,
as
Lordship.
Wakalatnama, Lordship.
The order dated 3/5/2025 of the Foreigners Tribunal number 2, second, Nagaon, is also noted on presentation by counsel for the petition.
মাস হবে।
Noted and left as part of.
Supplementary item 41 for motion.
Ms. Verma, in this case, they have corrected the past title. So we issuing notice. On 14/7, we passed the order,
Yeah, not to depart.
but later on, we came to know that this nomenclature was wrong. So we had to recall the order to allow them to amend the petition. They have done so. Now we are making the same.
District commissioner.
Yes, Lordship, I'm on put number 6, but sorry, I'm not. Only.
This is one of the cases which gave us a lot of trouble, and it has made me change my orders. I was always, what you call, trying to expedite the matter on the condition that the lawyers who are asked to amend the cost title shall do it within time. In this case, you did not do it. We had to recall the order, and then you made the amendment of the cost title, and again the cost title of respondent number 5 has not been corrected. So therefore, now we have changed our pattern. We are now not passing any orders unless the cost title is corrected. So instead of,
4 and 6.
no, that is there, but you see again, Superintendent of Police 5 is Superintendent of Police. It remains. So trying to help you has caused us a lot of headache in this case. We thought that we'd issue notice so that you can do it in the meantime. You said that you will do it, and then you don't do. Despite. Order dated 14/7/2025, indicating that the nomenclature of respondent number 5 is incorrect. The cost title has not been amended. Yes. Even double three.
Thank you.
Yeah. In the meanwhile, the records of the tribunal is received. One last opportunity is granted to the petitioner to amend the cost title within 2/8/2025, failing which appropriate orders will be passed on the next date of listing to strike out the name of respondent number 5. List this matter on 11/8/2025.
Upgraded item 34.
He's been released. None appears on out for the petitioner. However, Mr. A. Gayant and CGC as well as Mr. S.C. Kyal and standing counsel for the NCB are present. That's good. The learned standing counsel for the NCB has submitted that in the meanwhile, the 1 year detention period against the petitioner has already expired. So he plays for some time to obtain instruction as to whether in the meanwhile the detenue, not petitioner, detenue. Namely, what is the name of the detenue? Petitioner. The petitioner is the detenue. Okay, then Srimati Ling Chong, okay. It has been released or not. Next, released on 8/8/2025.
Lordship, may I please? Lordship, can it be taken after sometimes? Lordship, item 34. Lordship, actually, my senior counselor wants to argue here, and he is for a Friday prayer. He has gone for a Friday prayer. Miss A. Hussain. Hussain.
Upgraded item 36.
I'm appearing for respondent number 1. The petitioner is not there, but we moved an IA. This contempt petition is under Team 1B, other person with the consent of the advocate general. They have annexed the consent of the advocate general. The document can turn to page 29, which is the consent of the contempt petition. 29 of the contempt.
Is this matter as early as possible without in a bench without one of us living back. Which is
Upgraded item 37.
Wait, visual. My lord, this interlocutory petition has been filed, my lord, for releasing the petitioner, my lord, from the detention camp, my lord. Then, my lord, the petitioner was taken to the detention camp on 17/5/2025, my lord. My lord, my lord, the opinion dated, my lord, in the advantage written as 25, actually it is 22, my lord. 24/5/2022, my lord.
Which page is the opinion?
And the lot will find, my lord, in the main petition, my lord. Main petition case 47, my lord.
Mr. Sharma, we give you a short notice since in the detention camp. He's lodged where?
My lord, Matia, my lord.
Matia.
Transit camp at Matia.
We give you a short notice of 10 days. In the writ petition, which is the best document you have to connect you to your parents?
My lord, the brother, my lord, has deposed before the, my lord, younger brother has deposed before the tribunal, my lord. And one, another certificate, our certificate was there, my lord, consent certificate, my lord. But that was not proof, my lord. Others, my lord, petitioner's name had appeared from 1985, my lord.
Who is Hatem Ali?
Hatem Ali, the father of the petitioner.
Father.
My lord. Hatem Ali's name appeared in the April of 1966, my lord, page 14, my lord.
And who is Bhanu Nessa?
Bhanu Nessa, my lord, is the present petitioner, my lord.
He's the
He is
petitioner.
daughter of Hatem Ali, my lord.
She is the petitioner.
My lord.
Bhanu Nessa.
Bhanu Nessa, my lord. My lord, he is suffering from illness, my lord. That is why, my lord.
But her evidence is not inspiring. Page 31.
Yes, my lord. I am.
She does not have a voter list along with the parents.
My lord, parents voter list, my lord. Page 14, my lord.
No. Her voter list is, first voter list is at,
Yes, my lord.
where
Not
is her
parent, my
first
lord.
voter
Her
list?
husband, my lord.
Where is that?
My
Page
lord. Yes, my lord. Page, my lord, 17, my lord.
17.
Yes, my lord. Husband's name is Fazrat Ali and his name is Khalid Nessa. After getting married to Fazrat Ali, my lord, her name deported, my lord.
Yeah. Case is a bit complicated. You know what has happened? In your evidence, that's why we are asking who's the witnesses. Your father and mother did not come to give evidence.
Get that, my brother, I'll get that.
You please come to page 22.
Okay.
You did not give the date of death of your mother. It's left blank.
Yes, my dear, it is blank, my brother. Yeah, my lord, in the deposition, my lord, it has stated that my mother passed away 12 years ago, and father expired 20 to 30 years ago.
But you see, you
31,
don't know
my lord.
anything. That means you are making your case out of the voter list available.
Right.
How will somebody forget parents, forget their own marriage age, forget everything? Your voter list was 1980,
85.
85.
Right.
Which page was that?
Page 17, my lord.
17.
My lord, one.
So from your exhibited documents, can we find out any document which connects you to your parents? Panchayat certificate is there.
Yes,
Which
sir.
page is that?
That is there, my lord. Page 20, my lord.
Did this Panchayat secretary come and depose?
No, my lord.
Then how do you connect yourself to your projected parents?
My lord,
If the panchayat secretary did not come and depose, how do you connect yourself to your projected parents?
my lord, brother, younger brother, was my lord. So GW was two, my lord. Abdul Barak. Just 33.
Where is the evidence of your brother?
My lord, brother evidence is at page 33. And position, what we find at page 47. Now, in this evidence method, yes, Barakali had annexed to voter list, my lord. Voter 297 as well as 2008 and.
You're making things very difficult.
My lord.
You're making things very difficult. You see, in if there's something other which is wrong or we are unable to understand. In 2000, you come to page 26 or 25. So in page 25, 55 years in November 2017. Page 26, 55 years as on 6/11/2017. Now your brother comes Barik, Abdul Barik at DW2, page 33. He is 55 years as on April 2018. Not possible.
My lord.
And in your written statement, have you introduced your brother?
No, Lord.
No, no. There is no.
Then
Only father, mother and two.
because if it is not there, oral statement can't give you citizenship.
Maybe due to the lack of English council.
Pardon me?
Probably that will not disclose matter. Evidence from the evidence also matter.
No, that we can't say right now anything, we can't comment. But when we are examining it, there must be some document to connect.
Matter. Here, my lord, in the deposition of the brother, my lord, he has statement he is 1 year elder than me. 1 year difference.
That is why we have shown you.
Yes, yes.
That is why we have shown you. Now he becomes younger.
No. Barakali was 55 in the year 2018. And he was 55 in the year 2017.
No, because you see, wherever we read, we find your family interesting. My esteemed brother has correctly noticed it. Can you please come to page 31.
Right.
Last third line, I have completed 21 years of marriage, but I have forgotten the year in which I got married. So this is 2019. 2019 minus 21. Minus 21, it will be in the year 1998, correct? Now, please come to your brother's evidence. Page 38, to paragraph 7. I got married on 12, my sister got married on 12/7/1981. Very precise date. Yes, sorry, instead of bail, we have to dismiss your petition. Can't take it. Okay, we are reserving it for orders.
Right.
You have to say.
I think my lord, only thing is that apparently, my lord, there is no link lordship. And only link certificate is the Panchayat certificate that was not proved. And lordship, regarding brother's evidence lordship, he never pleaded in WS lordship, that he is an elder brother. And lordship, brothers, if lordship will see the brother's evidence is of village Oporupi and lordship in Panchayat certificate. These are main links.
Please come again. You missed it. Please repeat
Lordship,
again.
Page 37.
Page 37, yes.
Yes, lordship. His brother, projected brother lordship, he is the resident of village Oporupi, PS Kalgisia district, Borpeta, Assam. And lordship will see the Panchayat certificate. The present proceeding was resident of village Bongugi. That is his parental village was reflected as village Bongugi. And lordship earlier 1966 voter list was of village lordship Simlabari.
Just a moment. You're referring to page 20.
Yes, lordship. This is of
Bongugi.
village Bongugi. This was reflected as parental village lordship. And he was married to village Santospur. Then lordship is relying 1966 voter list of village Simlabari. So lordship page 14. And lordship, all these things are
Similaguri falls under Gondogi Kampul. Similaguri village. And this is considered certificate, no Gabura certificate.
And all these things are not mentioned in neither in his WS nor in his evidence lordship when they have shifted to village from Simlabari to Bonkugi or Oporuki lordship. That was not mentioned lordship. And lordship, another important aspect is that lordship Abdul Barek, who is the projected brother lordship of the proceedee, his name nowhere reflected with his projected father lordship. So lordship. And
Oh, for that he has a reason, because if the father died in 1972, his name will not be there. But that introduction is not there in the.
yes, lordship, and that
It's
may happen,
statement.
lordship. But otherwise, lordship, there is no link at all, lordship.
Is the records of the tribunal is received or the. Matter was heard, this will be great petition. Great petition. Matter has been heard. Upon submissions concluded, judgment is there. Yeah. But the hearing in the connected WPC 488 of 2023 is concluded. Accordingly, appropriate orders will be passed. On announcement of order in the connected hearing.
On fair matter, in that I am alert, I have only written the date of opinion matter. That's 24/5/2025 matter. Actually, it
That is okay. You said 22.
20.
It's a mistake, huh?
And
You're not.
that one respondent is lordship member for another tribunal, lordship. That may be checked also. One respondent was lordship imputed lordship as
Member of Foreigners Tribunal, Lordship, that may be type of.
That was earlier a main petition, my lord, but in the IA, my lord, I had already deleted.
No, no, but this order has to be passed. Just note it there. Just add one more time. In the petition, it is noticed that the respondent number 5 is that the member, Foreigners Tribunal, Bongaigaon, number 2, Abhayapuri, is rated as respondent number 5. As the said, respondent is not a necessary party in this case. Court is inclined to strike out the name of respondent number 5, however, without altering the seriatim of parties in the writ petition. The seriatim of respondents in the writ.
Right.
And this 20, it will be 22.
Yes, sir.
See. There was a request for upgrading item 38. We are upgrading it on, we are taking it up on Monday. We have to rise for some. Yes.
38.
Monday.
We've already said 38 will be on Monday.
Single bench item 1 with 2. Bail hearing BA.
Your Lordship, yesterday, Your Lordship, 2 more witnesses were examined, Your Lordship. Your Lordship, kindly the up-to-date scan copy may be called for Your Lordship. Scan copy of the other witnesses may be called. Only, yes, Your Lordship.
After we have taken up the matter, how many witnesses have been examined?
Till yesterday, Your Lordship, 8 witnesses were examined. Before Your Lordship, 6 were examined. Yesterday, 2 more were examined, Your Lordship. Because of these 2 witnesses, Your Lordship, the name of this accused petitioner's name was charged in the as an accused, Your Lordship.
Okay, so you want the evidence of
The
PW 7 and 8.
7 and 8, Your Lordship.
I have configured the NCR, Lordship. Teacher.
Next, it is fixed on 18/8, Your Lordship.
As Nazil, counsel for the petitioner, is that the evidence of PW 7 and 8,
8, yeah.
which have 7 and 8,
7 and 8, Your Lordship.
which have been recorded in the meantime, may be requisitioned. Mr. P.S. Nagar, under the APP, has submitted that has written the case record which was handed over to him out of dated 28/7/25. Next paragraph, the registry shall also be scanned copy of the evidence of PW 7 and PW 8. Recorded in connection. Recorded by the special judge. Recorded by special judge.
Definitely. Definitely.
No, sessions judge. It's another session judge. I got incidence case number 111 of 2023. Arising out of Jogikova PS case number 56 of 2022. He called for to email. It reverted to this headline court to send the scan copy of the evidence that was significant of 7 and 8. Email for the place of the report. Next response 12 8 25. Okay. 18.
18th of 18th on 19.
It was 7 and 8 and any other witnesses that will be examined in the meantime. Just on 18 8 25.
On next date is fixed, Your Lordship. Date is fixed. On which date the date is?
18.
18, on 18, the next date is fixed for the trial court, Your Lordship. On after 18, 19, Your Lordship.
No, in 19, then it will be 20 then. Then 20.
20.
20. Because in one day they will not scan it, they will not be able to scan it and send it.
Yes.
Evidence is taken by computer by the stenographer.
Yes.
It will take some time to type it and then send it. 20.
Deeply obliged, Your Lordship.
Item 3 for orders.
Last 7th of 2025, when order was passed, in fact, actually passed in this plan. Because the salary for the members of the foreign tribunal as well as the staff will be paid at that time, but there was sanction to pick up for some time. Now,
Before we take up this matter in the open court, can I request both of you to please come in the chamber? And
copies of these orders. After the order passed by the 7th June 2025, regarding the payment of salary to the members of the tribunal, the tribunal has to be. The first page foreign return is making very clear that now the for salary part of the staff as well as members here and GLR, GLP also thank you. That's all. Thank you.
Yes, two issues were there basically. First issue is with regard to salary and second issue is with regard to the DLR and DLP. They have given from May to December. They will explore the possibility of giving the back volume. That is one aspect of the matter. And second is that, my lord, one communication we have received with regard to a retired foreign tribunal member. I'll furnish a copy to my senior, my lord. He'll just look into it, my lord. He has some dues. 5,85,000 from the government after his retirement. These were, my lord, his salary due. Also, can take a
look at, and my lord, I'll serve a copy. Because it is connected to home department, you'll have. Area, the thing. अच्छा इतना बता कैसे पोस्ट everything sanction to be same member yes 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 and the member foreigners tribunal number 1 Gwalpara, he has written also to the deputy secretary Govinda Basam on 13 February 2024 for allocating the budget, but that is yet to happen. Look, there is no requirement to pass at this moment any judicial order. My senior will use his good office and superintendent. Superintendent. The amount period is 9/11/16 to 8/11/18. Yes.
Here's the copy.
Ase?
Yes. Normal. Basically, what is after you become.
Yeah.
So far as year date is concerned, I plan to point out that the possibility of it's a painful use. Better that for the future, it has to be continued. Thankfully, if we go then to what extent? Last year, 2 years, 3 years. It's better that in future, no. I understand.
Yes. Yes.
I understand. For this also, why I'm pointing out, for this also, what I'm saying is, for this also, by the earlier communication, they have communicated, we do not make the budget provision. But if the court passes an order, we hold the possibility of somehow getting the budget. It's how it is done. Now, instead of going for the back for the time, it's better that in future, it will continue. Area what is the expected why it will be we do not yes then I think we should write to the employer. Let the employer explore and find out what the reason for it.
It's also the
Thereafter, if they respond,
in 2 seconds,
exact.
it's already been meeting to the principal.
Yes, that's it.
Yes, that's it. Not so. First bit. Yes. Prior to that, there is a letter by the FT member to the deputy secretary.
It appears to be written to the government for example. What is the reason for not?
Yes.
Yes.
Yes. Yes. Yes, two different letters.
Or they will pass the order. That is like a kind of.
Yeah, that is all.
My.
pursuant to order dated 27/6/2025 of the learned additional advocate general has produced a copy of letter number PLB, which of 28967/1692 dated 29/7/2025, issued by the Joint Secretary to the Government of Assam, political within bracket B, bracket close department, along with copies of notification dated 15/7/2025, or thereby extending the service of members of, how many of them are there? 93 members of the Foreigners Tribunal beyond their earlier term up to 22/5/2026, with the exception of the member at serial number 37 who is superannuated in the meanwhile. Also appended thereto is a further notification dated 7/7/2025, another notification by which the term of 64 additional additional members of the term of the members of 64 additional foreigners tribunal in the state of Assam was extended up to 22/5/2026. Also appended is an order dated 29/7/2025, by which wait, 29/7/2025, by which orders have been placed for procurement of GLR for May to December 2025 for 93 members of the foreigners tribunals, as well as letter dated 28/7/2025, by which orders have been placed for supply of GLT for May, December 2025 for serving 93 members of the foreigners tribunal. Next one. The notice of the considered opinion that has basic law books and the essential law books, as well as the journals like GLT and GLR are essential for dispensation of justice of the competent authorities in the state government shall explore the possibilities of further extension of the procurement of GLT and GLR for the coming year 2026, and also to explore whether it could be possible to have the GLT and GLR also procured for January to April 2025, so that the entire set is complete. Next one. the learned amicus curiae has produced a copy of a letter dated 18/7/2025 received from a former member of the Foreigners Tribunal indicating that some arrears are due to be paid to him. So a copy thereof has been provided to the uh, what is your name?
Sir.
A. D. Devi. D. Devi, learned counsel assisting the learned additional advocate general. Accordingly, for the additional advocate general shall transmit the same to the competent authorities in the Home and Political Department. So those are it. Next paragraph. As this is a bench taking out infrastructural issues relating to the Foreigners Tribunal. To request the additional advocate general to use his office to find out if the infrastructural facilities are the requisite infrastructural facilities are available with the in all the foreigners tribunals functioning in the state of Assam. And if necessary to it is necessary for the Home and Political Department that do they need to needful in this regard. Next one. The second second the energy of civil pending section shall make a photocopy of this of the order sheet and hand it over to the learned amicus curiae just to enable him to examine what are the immediate issues that should be taken up by this bench. And to make his submissions from the state of Master. The court is informed that there is a direction by the Supreme Court of India that this matter be taken up every month. It is proposed that the matter would be listed in the first Tuesday of every month. Tuesday. Friday, I think, 2 o'clock. So because those are motion days also, we have to motion days also. That is also motion based. Can it be Thursday then?
Thursdays, not Thursdays, some difficulty. The other bench who is taking up the High Court matters, all the matters are taken up on Thursday, my lord.
Okay.
Tuesday will be convenient, my lord,
Tuesday.
if not inconvenient to my seniors.
First. First Tuesday of every. Next. Accordingly, this is the matter. Next. 2/9/2025. 2nd of September.
Yes. Look at 2 p.m.
At 2 p.m.
Ah.
So now we are asking the court master to have this order sheet segregated. Because it is now in the same file. It's very inconvenient to look at the order sheet. It is transmitted in the second file. In the meantime, the second section can give a copy to him.
Yes.
No, you see, if we listed, it can have, we had a video conference. Because if it's an infrastructure bench, it has to be taken up. And when there's a direction of Supreme Court of India.
1 or 2 day, my lord, previously also it happened, and that
Right.
1 or 2 day, it can
Let
be.
us say if one in, we have just, you
Yes,
see, this is what we are proposing.
yes.
And we are passing an order to fix a particular day.
And this particular date is subject to, obviously subject to availability of
We
lordship.
are fixing it.
Yes,
everyone. You see, the registry will not fix it by virtue of that observation.
Yes, ma'am.
They will fix it on the basis of the orders passed.
Yes,
So preferably we have said
yes, yes.
second
September.
Sorry, first Tuesday
First
in
Tuesday,
the,
yes,
in
yes.
every month. But let us say in one particular month there is a vacation.
Yes.
It can't happen on that day.
Correct, correct.
So we change it by convenience, but it is for your convenience.
I understand.
So
Yes,
that everybody, you also know, have a mental note that is every
Yes.
first,
So
second,
and so
third is
forth.
coming up. Here is a good point.
Yeah. Much of it, deeply.
Item 4,
Look, this is a small prayer for correction of the order of Lok Adalat. And there are some clerical mistake. This case was settled without any TDS lordship. Total 5 lakhs. But inadvertently, in para number 6 of the order of the Lok Adalat, it is mentioned that the balance amount would be subject to deduction of 10% TDS.
Which page?
Page number 3 of the order. Order of the Lok Adalat.
Is 3 of this IA.
IL. IF order is enclosed. The order page 3 look.
Yes, what do you want? What do you want, Mr. Agarwal?
Yes, Lord, sir.
What do you want?
That the settlement is without any TDS. That was a lump sum settlement. So this TDS portion should be omitted here. Pair number 6.
No, TDS is something which can't be avoided by a judicial order. Can it be avoided by a judicial order?
No, Lordship, in the settlement it was without TDS, Lordship.
But if you don't have a.
And
that, it can be
they sent the
removed in
check of, check also they sent, but it is not accepted by registry. So TDS portion is mentioned, Lordship. This was coming immediately in the January, month of January, they sent a check, Lordship, of 375.
I think follow you, please send it.
The rough copy only, Lord. And settlement is there in the main appeal, Lord. Settlement order is there in the main appeal. There it is means balance to pay rupees 375. This is rough copy, Lord.
But you have already received the money.
No, I have not received the money because it is not accepted by the order. Yes, Lord. So if it is corrected, then they will accept the check, Lord. Settlement was without any TDS. Lump sum settlement.
No, but TDS deduction is by operation of law. Can we stop the operation of law?
I've been told.
Earlier,
In the other two cases,
there are three cases.
there the amount had. We have the actual interest, it was come up to that.
Yes.
Yes.
So other two cases, the analogous three cases were there. So in other cases, TDS has been deducted.
It shows the order, where is that? Take it in next week, you bring that order. Because the operation of law, we can't, say the operation of a statute. Otherwise, you'll have to give an undertaking that if any tax is due on that, you'll have to pay it to the government.
No, Lordship, the settlement may kindly be seen, Lordship. Settlement sheet in the main appeal.
We've seen that, but you said that there are two other orders. First, that will make up our mind. Next week, we get listed. Okay, order. List again on 6/8/2025. It's a both sides are represented. The land ask for the applicant submits the requirement of TDS be exempted. As the settlement in the local adalat was for a amount of rupees 3,75,000 without
Balance amount that was earlier 125 page 3.
balance amount of it. Would be subject to deduction of TDS. However, as per the settlement arrived at, component of TDS was not there. Let the you have a settlement sheet with you? You have a settlement sheet with you? But it will be with your company. In the inventory. Mr. R. Goswami done that. Then the respondent shall obtain a copy of the settlement sheet. This one. Okay. We're listing it on.
Date is given, Doctor. 6/8.